This is a tutorial that tends to evoke a lot of responses from the audience. We've been giving this talk for about 4 years now. And it's one that I usually run out of time. So I'm actually going to start on time because we usually get quite a bit of interaction from the audience, which is a good thing, by the way. So feel free to ask questions along the way. I will be walking around a little bit. I used to teach for a living, and I carry a stick. So not to threaten, but please don't fall asleep on me because you may be tapped on the shoulder. So just a fair warning. So today we're going to talk about the EU GDPR, the General Data Protection Regulations that's specific to the EU, although it has effects globally. Actually, you don't have to be a company that's based in the European Union to be affected by the GDPR regulations, and we'll discuss what some of those implications are. Feel free to ask questions along the way. This is an official SNIA tutorial, unlike the one that I just gave across the hall an hour ago. So there's a little bit more rigor, a lot of peer review that goes into these types of tutorials. So it's been heavily vetted by many, many folks within the SNIA organization, which are representative of many, many companies globally. I'm also not a lawyer. We're going to talk a lot about laws today and regulations. So I like to specify that up front. I am not a lawyer. I'm not giving legal advice. So please seek appropriate legal counsel as you see fit. You are welcome to use any of these slides. As you may have heard in other tutorials, you have to give proper attribution back to SNIA if you decide to use any given slide. These will be posted on the SNIA.org website if you guys are interested, in, just like all the SDC presentations. So as an abstract, hopefully you've read the abstract. I'm not going to read it to you, but it might be the reason why you're sitting here. There's a bunch of countries that are members of the EU, soon to be potentially less than 28 countries. Why? Brexit. So potentially the UK, which is they're working on. So what we're going to do is start with a little bit of definitions. Privacy versus data protection. So privacy, we're going to give you a couple of definitions. This is actually by the IAPP, the International Association of Privacy Professionals, of which I am actually a member of. And they actually have a very specific definition of what privacy is. I'm not going to read it to you, but I think the most interesting thing about how we in the US define privacy, very different from how privacy is defined in the European Union. So when we talk about privacy in the US, it's talking about the personal identifiable information, all that stuff, how that stuff gets secured, stored, managed, and so on. Privacy in the EU is very, very specific to everything that has to do with identifiable information as it regards to each respective what they call data subject. In other words, if you're a member of the European Union, of any of the EU countries, you have very, very specific rights to your personal data. However, they refer to that as data protection. Well, we would refer to that as privacy here in the US. So it's almost a reversal of terms. And the other definition I'll give you here on the bottom of data protection, and this is actually coming also from the IAPP, the International Association of Privacy Professionals, gives you the definition of how we define it in the US. A little bit in the EU, the second sub-bullet tells you in the EU they actually refer to this as privacy, basically. So what we would refer to as privacy, they call it data protection. So a little bit more definition from a storage perspective. It's kind of interesting because I co-chair a committee called the Data Protection Committee within SNIA. Internally we call it the DPCO just because we don't like to mention long names. The DPCO is just finishing a white paper on data protection, kind of interesting. Well, another technical working group within SNIA is also doing a data protection white paper. And that group is called the Security TWIG, the Security Technical Working Group. what's kind of interesting, because you might ask, well, why are two different subgroups within SNIA doing the white paper on the same subject? Well, the reason is the security twig is actually doing it more from an organizational, operational, policy-based, how you do security. From the DPCO, the Data Protection Committee, we're doing the best practices white paper based on more from a storage infrastructure standpoint, if that makes sense. So that's the difference. Sometimes when you hear about data protection, even in the US, data protection, depending on if you're talking about from a security side or from a storage infrastructure side, could be very, very different. Hence, two totally separate white papers on the same subject of data protection. Kind of interesting, isn't it? Anybody fallen asleep on me yet? No? Good. Don't forget I have a stick, so I used to teach for a living for those that walked in late. If you get a tap on the shoulder, that means you're falling asleep on me. I don't allow people to fall asleep on me. So just fair warning. So this is being recorded also, but the video is not. So keep that in mind. So anyway, directives. So when we talk about GDPR, there's actually two different types of laws within GDPR, the General Data Protection Regulations. Part of the laws has to do with what they call directives. Those are laws that say, okay, well, here's the general framework. You within each member country of the EU, you figure out how you want to implement it into law. That's what their directives are. Versus a regulation, the laws are very, very specific and they apply to all member countries of the EU exactly the same. So that's the difference between a directive and a regulation. Any questions? So in the EU, there's actually been regulations for a very long time. So GDPR is just the most recent fruition of a lot of their data protection laws over the years. Where it grew out of is some of the EU regulations called the 95 directives. They also had in the 90s, late 80s, early 90s, what they call the DPA, the Data Protection Act, if anybody has heard that, in the European Union. So those were actually much more high level. The GDPR is actually much more specific. So there are even fines in the Data Protection Act, but the fines are much more specific and they're actually much more stringent now. In other words, if you are fined because you're not in accordance with the law of GDPR, the fines are actually much more strict than they have been in the past. What those are, we'll talk about in a few minutes.
So, actually a question.
Yep.
Talking about fines makes me wonder about directives. What happens if a government or an entity doesn't actually provide a regulation onto a directive?
Oh.
It doesn't hold to that country. You have no rights.
Yeah, so there's what they call a data protection authority, and there's a data protection authority for each member each member country within the EU. The DPA, or the Data Protection Authority, actually sort of reports to the EU Parliament. The Parliament is what decides all these crazy laws, be it directives or regulations. So it is part of the EU Parliament's responsibility to make sure that laws are in fact in place, even if it was originally a directive, to make sure that it's in place in some way within each member country. So there is no free ride, so to speak. So there is quite a bit of oversight. In fact, a lot more oversight than we are used to in the US. Kind of interesting. Not that that's good or bad, I'm just pointing that out. And then the directives replaces something else. I won't get into a lot of the legal jargon here, but the point here is that when GDPR was written, and by the way, it's been ongoing for quite a few years until it was finally passed in April of last year. It'll become law in May of next year because there's a 2-year rolling in period. This has been going on for a long time, but these regulations were actually born from other regulations that were predecessors to what we have now as GDPR. So here's where it gets interesting. So personal data. They define personal data much more strictly than any other governing body globally that I know of. So, for example, at a high level, any information that relates specifically to a data subject, what they call a data, in other words, a person. You just have to be a member of the EU, any EU country, to be a data subject in their definition. Well, it could be anything, and the third sub-bullet is the interesting part here. Any data that could be pointed back to you as an individual. Well, notice what some of them are listed here. Kind of interesting, right? Some of the stuff you do on social media, your medical information, your computer's IP address. Wow, that's kind of interesting. Why would they even attempt to put into law PII, personally identifiable information, as your IP address? Why? Localization, right? In other words, there are ways of finding out what? Yeah, where you live, potentially who you are based on if it's associated with a registered domain name, all kinds of weird stuff, right? Not always the case for every individual data subject, but it could be pointed back to you specifically as a member of the EU. Very interesting. We've never seen that codified into law in any country until now. So what they call a data subject, I already mentioned this is basically any person, more or less, within the EU. The interesting part are the sub-bullets here as well at the bottom of the screen. Location, data, right? Your GPS crap that you use on your, your wonderful stuff that you use on your, sorry, this is being recorded, I should be careful. But also things like genetic identity. So all this stuff with like DNA stuff, right, is becoming more and more popular. Ancestry stuff, right? I try not to mention specific names, but you get the idea. Mental identity. That's interesting. Right? That could be based on maybe a medical consultation that you had, and the result of that was potentially something that might have said, oh, you, based on this consultation, have the following mental capacities. Well, depending on how that data is used, sort of think forward a few steps. So, for example, if there's another body that wants to use that information to call data to be able to produce a study that talks about different geographies within the EU, that information could be used, right? It's the output of some medical consultation that you legitimately had with your doctor, let's say. But if it's used in the wrong way and used inappropriately and potentially other metadata is associated with that data, what could happen? It could be associated with you specifically, not just scientifically, that person within that geographic data had that mental issue, whatever the issue happened to be.
I previewed these.
Good.
I thought that meant like a psychological profile, which you could actually have, because that is actually, could be a very strong identifier.
Yeah, and that's another example. I was just giving you an example, but you're right, psychological profile is another example of this concept of mental identity.
If you're not sure, and it's probably identified.
Yeah, and it's purposely written kind of vague, right? Why would you guess why it's sort of vague from a legal perspective? Why?
A piece of information by itself is just a piece of information. But if you get enough of this information and vector it together, then you can hone in on individuals.
Right. And they're sort of, meaning the EU, they're actually gearing the legal terms so that it's actually favoring the individual rights of the EU members, not the other way around, not the people that those individual members may want to sue later on. Kind of an interesting, very, very different from the perspective of what we've seen in the past. So, there's some interesting things that come out. So we could actually spend hours on reviewing GDPR. There's about 99 articles. There's a whole bunch of other things within the actual GDPR. legal framework. By the way, it's all posted publicly on the web, so if you're interested in reading at night, you're more than welcome to download it. It just so happens this is one of my areas of expertise, so I have to be very familiar with the specific laws. So unfortunately, I know it pretty much by heart, and that's an unfortunate thing in some ways. That's a joke, by the way. So, but one of the things, and I can only highlight a few major things because we honestly don't have time. One of them is express consent. So within the GDPR, you are given the express consent to do what? What does it say? Yeah, one of them is the right to be forgotten. Well, that's kind of interesting. If you're interested, this has already been litigated in the EU. Does anybody know that? I think someone's here from Europe, I think. Okay, there's a few of you. So there's already been case law already cited. Even the GDPR isn't officially in effect until May of 2018, next year. This has already been litigated. The right to... Who was it? Individual or a court? It was an individual, right? Yep. Who won? Who won? The individual won, right?
So here on the, you know, you can go to Google and say,
Yes.
and it will not show the Europe anymore.
Right, so I would repeat that because that's an interesting one. And there's people way in the back of the room that may not have heard it. I usually use that as an example, but someone else used it, which is really good because I'm not supposed to be calling out specific companies because that might be seen as being biased in any way. By the way, I don't work for Google, in case you're interested. So someone mentioned towards the front here that that gives the individual members of the EU the right to go to someone like a corporation like Google and say, hey, listen, Google, I just woke up this morning, I decided I want to have all my data that's on the Google websites deleted. Which, in and of itself, that actually sounds easy. Google will just push a button and delete your data, right? That's not so. Why is that not such an easy thing for someone like Google, who has some great ideas and some great technology behind them in data centers that are globally distributed across the globe? Why is that not an easy thing to actually do, delete someone's data? What's the big deal? I'm sorry?
Those vectors come in, like friends and family.
So social media stuff, right? But what's another? Third-party stuff, right? So Google does what? They take the data and they do what with it? They share it. In some cases they do what? Sell it, right? I hope I'm not offending anyone, but this is what Google does. That's their model, right? That's their business model. This is not shared secrets. This is what they do, right? So you have all this data, but they also have applications, right? So if you happen to use their mail application, which is called what? Gmail? Okay, so you have Gmail. Okay, that's one thing. But what about all these other applications that you may in fact decide to use that are Google-related applications, right? So now you have all this data. Some of it is social media related, but a lot of data dispersed across multiple data centers that are owned by Google. But if it was just that, Google can probably deal with it. The problem is now you have issues of they sell that data. That's number one. Number two is they have issues of people doing what with that website data. On your own computer, you can do what? You can cache it. You can cache it locally, which means what? You now have a copy. Whether you like it or not, I'm not saying this is good or bad, I'm just telling you the reality. You now have a copy locally on your computer of the data that was on someone else's server in some godforsaken data center somewhere, which may be across the globe, may not even be in the EU at all. Right? There's another issue that comes up, this is sort of one of my favorites because one of my interests is data protection, so we talk a lot about backup. What happens when Google does things like backup? Well, what do they back up to? Just take a wild guess. One of them is tape. By the way, publicly they don't like to talk about that publicly. But believe it or not, one of the media that they use believe it or not, is actually tape, right? We know this because it's become public knowledge because what happened one time a few years ago? They lost data and they had to restore from what? Tape, and that was public knowledge. They had to actually disclose that to the public. Oh, sorry for those thousands of users. We're going to restore your data within the next 24 hours. And by the way, we're going to restore it from tape. They had to publicly disclose that because it was already in the news. So guess what? So now that you get a request from a specific individual within the EU and they say, well, I'd like to have all my data deleted. How do you delete that person's data from backup tapes? It's tough, right? I'm not saying it's not possible. It's expensive, it's time consuming, it's very difficult. And probably difficult even for Google to do it within certain time frames that the EU requires. Does anybody know what the requirement is? If you get a request from an EU member for a deletion request of all their personal data, how long do you have to respond? Two things. So there's one to respond, the other is to actually have it completed. The response is 72 hours. It has to be done within 30 days. If there's a reason, and this is in law, by the way, this is not hyperbole, this is actually written in law. If you, as the organization getting the request from the individual, cannot do it within those 30 days, you have to have a written reason back to the Data Protection Authority within your member country as to why, and then they get to say yes or no to it. So if they don't like your response, they can still say sorry, but you have to abide by the 30-day law. So it's a little bit more stringent than we've ever seen before. So I saw a question.
Do we know how that's shaking out, like whether they actually are denying?
Yeah. Have you heard of any for those from Europe? Yeah, so nothing that we've seen so far. For those that, for what was litigated publicly, it was fairly straightforward and there was no issue because it was fairly benign. There wasn't a lot of data associated with it, and it wasn't a Google type of issue where there's lots of data and it was a more specific use case. However, it's an interesting question because how are we going to see it play out come May of 2018, right? That's the...
It opens so many doors. We have to keep so much data, so many providers have to keep so much data for long periods of time for legal purposes.
Right.
Now you have competing realities of, well, we have to preserve this data for 6-10 years maybe for legal realities, but then now that's just creating even more and more data we have to scrub if somebody decides that they want to be removed from your system.
Right. Right. There are competing issues, right? Yeah.
So if somebody serves as a public official somewhere and that's part of the public knowledge, if he decides that they don't want Steve nodding office to actually scrub themselves from public record, is that considered as personal data or no, that is public data?
Well, it's considered their personal data from the very beginning if it abides by the legal definition of what personal data is, and that's pretty specific in the regulations. Now, you bring up an interesting point though, and I'm not sure this is your question, but I'm going to say it anyway. People now have the ability to actually change their mind. And they might say, okay, well, I changed my mind and I actually want all my data taken from your servers, and let's use Google, and because we picked on Google, but transfer that data to another third party to use that data for a similar service. Let's just say email as an example. Maybe it's not a good example, but if you're using Gmail and you decided, Google, I don't want my mail to be in Gmail anymore, but I want you, Google, to give me the ability to transform that data in a standard format to another third-party provider that will provide a new email service to me. That's actually part of the law, by the way. And that's tough. Why? A couple reasons. One is, how do you do that in a standard format? Number one, there is no format that's currently decided on. That would be the means by which one organization would transfer the data to another. They call that transposition of data. That's one problem. The other problem is there are provisions in the law that state that you have to give access to that individual EU member to that data, so that they might want to suck it down themselves to their own respective computer, not necessarily give it to a third party. So what does that mean? That means you have to provide a what? Portal. Right? A portal into your systems, plural, potentially plural, right? So that they have access and only access to their specific data. Just in the chance that they may decide that they want to pull it down themselves and then request to you to delete the data off of your servers. Wow, that's a problem for a bunch of reasons. Number one is a security issue, right? So now you're providing a portal to an EU member person to have access to their data, by the way, only their data, on your servers, but you now have to make sure that that portal works, but it's also secure only for the data respective to that individual of the EU. Well, that sounds easy, but it's not. Unfortunately, I can't get into it, but there's a bunch of security-related issues right there when you talk about providing portals to people's individual data, personal data, on your servers, and then potentially having the request to delete it off right after that. Crazy.
What happens with photographs where there are multiple people? You have a photograph of 4 people, and you want your picture out.
Yeah, that's a good question. Sure. Right. Those are all valid questions that have not been answered yet. I can take guesses as to how that would be litigated. If you have a group picture and you can't really necessarily expect that server company, whatever that organization is, to blot out everybody except you or vice versa. But it'll be interesting to see how it plays out. There's a lot of legal firms that are actually gearing up to actually start litigation starting May of 2018. Some of them are salivating to start to flood companies with requests. Some of them, they would like to be class action lawsuits. Why?
Well, I was saying that basically of all these things, there is no answer until the European High Court give an answer in maybe 20 years, and then we finally know.
Yeah.
Before then, it's impossible to say for sure.
Yeah, you just don't know until it starts getting litigated. In a sense, it's unfortunate. I don't see this as a happy thing going forward. I think there's legal firms out there ready to pounce, but for all the wrong reasons. It's not necessarily in the best interests of the individual members of the EU. It's because they want to make $1 or €1 in the case of, that was a joke, by the way. But so another thing within the GDPR is a breach notification requirement. This is big, right? So you have a requirement to actually provide notification if in fact there is a breach within a specified time frame. That time frame is actually pretty low. You have to tell the DPA, the Data Protection Authority, who I mentioned earlier in the talk, within 72 hours of a breach. You actually have to potentially provide identifying information back to those who were affected by the breach within 30 days. And again, I mentioned there might be reasons why you can't do that based on the number of individuals and based how large it could be, but you have to provide that in writing within that 30-day time frame. And they have the ability to say yes or no. This is big. One of the biggest parts that people are glossing over is this concept of what's considered a data breach. So part of the law, and this was actually rewritten last year before it got signed into law in May of last year, was that there doesn't actually have to be a breach necessarily. There could be a potential because there's information that shows that someone gained access to the system, but we don't know if there's exfiltration involved. In other words, you don't know if data was actually taken, but there is evidence through logs and so on that someone actually unlawfully gained access to personally identifiable information within a system. According to GDPR, by definition, guess what? That's a data breach. Doesn't matter if exfiltration was involved or not. That's huge, right? So as long as you have the knowledge within your company that is storing this data, that access to data was unlawfully taking place or potentially unlawfully taking place, by definition, according to GDPR, that's a breach. Which means what? You have to provide to the DPA, Data Protection Authority, within that, whichever EU member country it is, within 72 hours. And then, upon that investigation, you have 30 days to figure out if you have to notify individuals. That's big.
Doesn't that apply to every employee who shows up at the job and like have access to data? They might do something appropriate.
Right. So it's an interesting point you bring up. So I will restate that because some of you may not have heard that. So what if the breach could have happened from an internal employee that just happened to have a bad day or is getting ready to be fired, or maybe just got fired and they were responsible for the breach. The laws don't really care, according to the way it's currently written. By definition, that's a breach. They don't care if it's internal, if it's someone that you employ within your organization, or if it's an external threat from the outside. The fact that it's a breach, you have to report it. This is going to be big. One of the bigger things that we're going to, and by the way, one of the things that companies are ready to pounce is on breaches. Why? Because it's way too broad. You don't have to prove that a breach has taken place and that exfiltration of data has taken place. Just that there is a potential for a data breach based on what you see within the system itself. That's huge. So I'm going to move on since we're running out of time. There's some policies and measures in here. You do have, I mentioned this earlier, but the right to transfer data from one third party to another. That gets into the whole data portal thing. There's all kinds of security issues with that. The law is written in some definable standard format, where the unfortunate thing is there is no format that's been defined yet, so that's something that will probably come later. You have what they call binding corporate rules, and this also has to do with transfer of personal data, potentially from countries outside the EU to others, and then how you have to do reporting, logging, and all the respective things to make sure that you're not in violation of the law. So one of the things that companies are trying to figure out is how do we as an organization protect ourselves to ensure to be able to report back to the EU that we are in fact doing the best that we can to make sure that we're not in violation of the GDPR regulations. What do? You do what they call a data protection impact assessment. So it's very similar for those of you that are familiar with assessments, any kind of security type of assessment. It's very similar. The difference is the assessment is done from a very different viewpoint. It's actually from the viewpoint of the end user, not from the viewpoint of the company that you work for. Very different. So it's very similar in what you would potentially do from a policy perspective. Do this and then make sure you're reporting all this and logging all of the transactions and so on. But what you're checking for is how is that protecting the individual rights and the specific data that is personally identifiable information for each respective EU data subject. So it's a different type of assessment, but this is what you do. This is typically done by a DPO, Data Protection Officer, which I haven't spoken about yet. It's probably on the next slide, that each respective company needs to employ. It doesn't have to be someone that works for the company. It could be a contractor, but and in fact, it is on the next slide. So the Data Protection Officer is the way it's currently written, it's actually a requirement if you're dealing with data for 5,000 members of the EU or more. This has highly been lobbied to change, and in fact may change in future iterations of the GDPR going forward. Why would organizations want to change this? Any ideas? To make it a smaller number. Why? Because there's a lot of small companies, right?
They tend to be, in some cases, higher targets.
Yeah.
Yep.
Yeah. Smaller companies.
With other bigger companies in through another.
Right. Smaller companies, less data, but they also have less stringent security requirements typically. They can't afford all these crazy, fancy data protection impact assessments that may cost a lot of money. So there's a lot of lobbying to try and get that number to actually be a smaller number of 5,000 and make it even less. Or actually more in the case of small companies. But there's a lot of small companies that actually provide marketing services to larger companies, right? They're actually little contractors to Google, for example. But anyway, that's a big one. Yes?
Before you move on, that last bullet which is bold, said significant shortages are anticipated for these privacy experts. What do you mean for these privacy experts?
Right, so the data protection officers are folks that are employed either by the company or contracted by the company to work for them to make sure that they're in compliance with GDPR regulations. So by definition, these DPOs or data protection officers are experts in GDPR law. Very often, depends on who you read and who you respect and who you believe, very often the data protection officer, many people feel should actually be a lawyer.
Okay, so just make this a more grammatical question, and this is the way it should be of these privacy experts. Right. There's a shortage of them.
It's not a shortage
Yes.
of data, it's a shortage of the experts.
Yep, sorry.
I got you.
That is a grammatical, thank you.
Because I didn't know if it was a data problem or a person problem.
Yep, yeah, that's a good point. Thanks, we'll make that change. But I recently worked for a company that...
I'm a grammar protection officer.
Yes, yeah, I remember. And I appreciate that, Jay. So there was a company I previously worked for that actually assigned a DPO officer for their company, happened to be a lawyer that specialized in data privacy. So interesting little tidbit there. We mentioned a little bit about data transfer to third countries. And that gets into some interesting areas, especially as it relates to non-EU member companies. There used to be something called the, well, I'll get into it on the next slide, a regulation referred to as the Privacy Shield, but hopefully it's coming up on the next few slides. But the penalties are sort of interesting here. This has to do with breaches specifically. There are other penalties mentioned in GDPR, but this is the most stringent, and it has to do pretty much with things like data breaches. So it says things like 4% of the company's what they call global turnover, which to us means revenue. For a large company, that could be huge. If you're found violating GDPR laws. So how could you be found? Things like not adopting internal policies, you didn't do your data protection impact assessment appropriately, maybe you didn't designate a DPO officer when you should have, and there's certain regulations that state if you have a certain amount of data from external folks, EU members, anything more than 5,000, you have to have a data protection officer, things like that. So The other interesting part is there's a lot of latitudes. On the bottom, the sanctions could be dissuasive, proportionate and dissuasive. Well, that gives them a lot of leeway to pick specific companies to make them sort of targets to make a point, to be an example, right? They've already started to do that. And Google is only one example, and that's. In fact, I'll give you the Google example in a minute.
That first bullet means that incompetence is a crime.
Well, here's the interesting part, because if you read it loosely, you can read it where it's incompetence. If you read the law specifically within GDPR, which I have, unfortunately, again, that's a joke, but it's specific that all you have to do is prove that you are in compliance with everything that they say you should be doing. For example, assigning a data protection officer, doing data protection impact assessments, and so on. It's actually kind of specific. They don't tell you how to do it. In other words, they don't tell you how to do a data protection impact assessment, but you have to have records to say, we're doing it, and by the way, this is how we're doing it.
They shoot you guys, that just gets you. He was supposed to do it.
Right. Now, they may still have a problem with it if they want to make a big deal of it, or they want to make your company an example. They can still give you a hard time, but it's loosely written to the point where they say, make sure you do this, make sure you do this, make sure you do this. But it's still up to interpretation as to, well, what does that really mean? Does that mean I just have to show that I did a data protection impact assessment every 6 months? Is that good enough? And that it's recorded. By the way, you have to have documentation to show that. So there's a lot of interpretation, and they purposely wrote it that way so that they can get up one morning and decide, well, let's make an example of a few companies today. The road to approval, I'm not going to go through this, but the bottom is the interesting part. So there's that 2-year burn-in period. So it was signed into law a year and a half ago. It'll actually be officially law in May of next year. But again, litigation is already taking place. So, quick summary. Fundamental right, data protection. What we would call privacy, they call data protection as a fundamental right. Some of the approvals, we've already seen some litigation taking place before the law is officially on the books. If you guys remember this safe harbor, which was in effect for a long time, that actually got shot down in October of 2015 actually. And then they came out with what they call the Privacy Shield. The reason why Safe Harbor was, after many years, disbanded as an agreement between the EU and the US was one major thing happened in the US that sort of shook everybody's boots. What was it? This wasn't all that recent. It was a few years back. Snowden, right? The Snowden adventure. So they thought, well, yeah, this guy, oh, well, this is what the U.S. is doing with data. Oh, really? Well, they decided, so it was actually litigated, so it actually went to court in the EU. And the outcome of that was a side effort of disbanding what was the Safe Harbor Agreement, which was successful. And then they had to sit down with the U.S. and negotiate another agreement, which ended up becoming the Privacy Shield. That will also be probably struck down probably within the next 6 months, is my guess. There's negotiations going on right now with the EU and the U.S. to make further modifications to the Privacy Shield. So we'll probably see a lot of movement in that area, for better or for worse. Yep.
Do EU citizens retain these protections when they're attending a SNIA event in Silicon Valley? This gentleman is presumably an EU citizen. I'm an EU citizen.
So the answer is yes.
Really? And only with regard to EU service providers that are under this law, or by extension, multinational?
Okay, so that's really the crux of the question, right? So if you're an EU citizen, doesn't matter where you are physically today or tomorrow, if you have personally identifiable data, you have, according to the GDPR regulations, rights to that data. Doesn't matter if you're in the US today and you're actually from an EU country, you still have rights to that data. Doesn't matter which company stores that data, right? That company could actually be based in the EU, but doesn't have to be. And that's the point. A lot of the organizations today, and I'll sort of end on this point because I'm running out of time. A lot of the organizations today feel that the EU GDPR regulations only affect companies that are based in the EU, and that's not the case at all. It's covering everybody. Who it doesn't cover are companies that don't deal with any personally identifiable information of any EU member at all. And if you work for an organization that falls into that category, God bless you, you're in good shape. But that, unfortunately, is not the case for many, many companies. So you could be a company based in the US, like Google, for example. It doesn't matter where your data centers are. In that example, Google has data centers globally. Some are actually in the EU, some are not. But the fact is that they have data that is personally identifiable information of EU member citizens, what they call data subjects. So we're picking on Google only because it was litigated publicly, but
If I think that small businesses hiring people.
Yep.
As an example.
right. So there was one company that I worked for in the past that actually took this to the extreme. They had actually a help desk, and the help desk, even though they weren't based in the EU, they had a help desk in the EU. Well, part of the help desk was they get people that call up and say, hey, I got problems with my laptop. There's an internal help desk for the employees. I got problems with my laptop, but what's the first question they ask is, what? What's your name? Who are you? Oh, really? What's your IP address? Oh, really? Okay, well, what's the... So they started asking about, so they can identify, well, guess what? According to the EU, if that person who is your employee, even though the company is based somewhere else, like in the US, that's personally identifiable information of an EU member citizen, which they call a data subject, which means what? It's under scope, which means it's available for GDPR regulation.
Sorry, that's still subject to that 5,000.
It is,
requirement, right?
by definition, yes.
Okay.
By the way, that's subject to change in the future, but that's what it's currently written as. What did that company do in that example? They actually did what? They moved the help desk. Interesting. So,
How do they validate the request to be deleted? Because I can delete you, I can delete him, and they just say, we're going to request to delete
Right.
everyone in this room.
Right.
They're far away, we can't validate in person with a biometric
Right.
ID. Whoa.
that's tough, and that's actually loosely written in the law as well. There is no official way under GDPR regulation that states you will prove to us in this specific way. It just says, hey, you have to prove that if you have a right to be forgotten and someone says, I want my stuff deleted, you have to prove it to them and do it within 30 days, period. That's it. They're not telling you how to do it. They don't really care how you do it, but they just want to be able to go after you if you don't do it in some way, you know, if they can prove that you didn't do it. It's tough. That's a tough one.
So, how do they? I don't want to read. I don't want to read this, so I'm asking you.
Yep.
How do they define identifying?
Oh, we went through that before you walked in.
I'm sorry.
That's okay.
I didn't mean to ask this.
So I'll cover that in a minute, because I'm almost out of time. So here's the one Google use case that I wanted to cover before we break off. Google was sued in the EU. Actually, the ruling came in March a couple years ago in 2015. And there are a couple people, there was actually 3 British folks that said, hey, you know, you're taking my data and you kept my website information and all this other stuff, cookies and so on. And they actually won. And this was one of them that was publicly known. Does anybody know what the monetary value of that lawsuit was to those EU members? No. Why? It wasn't publicly disclosed. So we know about the lawsuit, but the actual settlement was out of court. So it was not publicly disclosed what they were given from a monetary perspective.
Is
Oh, yeah, well, Google will appeal anything. So I hope I'm not offending anybody, but they can appeal anything, but yeah, absolutely. So we talked a little bit about the Snowden adventure. Here's some, the American Bar Association gives you some guidance here, some interesting guidance. Probably good to think about if you're an organization based anywhere, really. And I'm just about out of time. Thanks for coming. I'll be around if you have questions afterwards.